Thank you for joining us for today's webinar on workers' compensation and COVID-19. I'm Adam Rossi from the Communication and Outreach Unit here at the Workers' Compensation Board. And today we will be discussing the basics of the workers' compensation system, as well as information to help workers who believe they contracted COVID-19 on the job, especially those who have missed time from work or are suffering from long-haul symptoms. We do ask that you please keep your phone lines muted. We will be using the chat feature to receive your questions today. You can enter your questions throughout the presentation, which in the chat box, which is located in the right side of your screen. You can enter them anytime, but we will hold off until the end of the presentation to answer any questions you have. We will answer as many of your questions as we can, but if you have questions that we either don't get to today, or if you think of something after the session ends, we will be providing you with resources at the end of today's presentation. Joining us today to answer your questions, we have the board's medical director, Dr. James Tachi, as well as our advocate for injured workers, Joe Cavalcanti, who is going to say a few words to kick things off.
Thank you, Adam, and thank you everyone for joining us today. As Adam mentioned, I'm the advocate for injured workers here at the board, and I manage an office of advocates, and we exist here to support the injured workers of New York State. We are here for you. So in today's presentation, we will be sharing important information about workers' compensation for employees who have contracted or who do contract COVID-19 due to an exposure in your workplace. As part of this, we will be detailing how and when to file a claim. And the when here is very important. And it's one of the key reasons why we're doing this webinar today. Workers have 2 years from the time they contracted COVID-19 to file a claim. 2 years. So if you believe you contracted COVID-19 in the workplace in approximately the late winter of 2021, you need to file a claim now. You'll also learn what to include in your claim to show you had COVID and to show that your COVID-19 was work-related. I look forward to answering your questions after the formal presentation. So now let's get started. I'll turn this back over to Adam.
All right, thank you, Joe. Let's take a look at today's agenda. We will start by explaining what workers' compensation is and what your rights are if you become injured or ill on the job. Then we'll discuss how workers' compensation can help those affected by work-related COVID-19, including workers who are facing ongoing or long-haul symptoms. We'll talk about the importance of filing a workers' compensation claim, and we'll walk you through the process of doing so, including the medical documentation that's needed to support your COVID-19 claim. Finally, we'll point you to some helpful resources for more information or assistance with filing. And again, we will leave time at the end to take any questions you have. So let's start with a brief overview of workers' compensation. Workers' compensation is a no-fault insurance system and is usually covered by insurance through an employer unless that employer is self-insured. We'll discuss this more a little later in the presentation. An employer cannot charge a worker for the cost of this insurance, and it provides medical care and lost wage benefits to the worker or to workers who are injured or become ill on the job. An employee is considered anyone providing services to a for-profit business or any compensated individual providing services to a nonprofit organization, regardless of employer size. The only exceptions are clergy and some school teachers, although the vast majority of school teachers in New York are voluntarily covered. There is no cost to the worker to receive the necessary medical treatment for a work-related injury or illness. This is a lifetime benefit unless the worker signs a settlement or Section 32 agreement that closes any medical eligibility for a payment. This includes all medical expenses such as tests, hospital visits, medications, physical therapy, equipment, and home care attendance. Transportation costs for travel to all medical appointments or treatments are also reimbursable for life, and there is no time limit to when a worker can file to have these costs reimbursed. Now let's discuss the workers' cash benefits, otherwise known as indemnity benefits. 2/3 of a worker's average weekly wage is payable while the worker is out on workers' compensation with 100% disability. This includes all compensation. So for example, tips, perks, etc. The maximum benefit is $1,125.46 per week. And this number is based on New York State's average payroll and is recalculated every July 1st. Benefits in the workers' compensation system are temporary, except in the event of a permanent injury. In that case, the worker will be reevaluated to determine whether they have a permanent total disability or a permanent partial disability. Finally, there are payments for a loss of use of a limb. This is known as a scheduled loss of use award and may be eligible for the following: arm, hand, fingers, leg, foot, toes, eyesight, hearing, or disfigurement. There is also a fatality benefit, which is payable in instances where a worker perishes due to an incident, consequence of a previous incident, or an illness, such as COVID-19, while at work. With this benefit, funeral and memorial expenses are reimbursable up to $12,500 in the New York metro area and $10,500 throughout the rest of New York. Surviving family members are also entitled to weekly benefits, which are calculated the same way as the indemnity benefit, which again is 2/3 of the deceased worker's average weekly wage. Beneficiaries include the spouse of the worker, children up to the ages of either 18 or 23, or any disabled or blind dependents. If none of these parties exist, $50,000 is payable to the parents of the deceased worker. If there are no surviving family members, $50,000 will be paid to the estate. In terms of who pays workers' compensation claims, that depends. If your employer purchased an insurance policy, the insurance carrier who wrote the policy will pay the benefits. If your employer is self-insured for workers' compensation, then your employer will pay the claims. Usually, self-insured employers will use a claim administrator to handle claims, so you will most likely be dealing with that claim administrator in that situation. This is known as a third-party administrator or a TPA. When the employer does not have the required workers' compensation insurance coverage in place, then the Workers' Compensation Board will pay the claims so that the worker can get the needed benefits, and then the board recoups the costs from the employer, along with any penalties for not having the insurance in the first place. Workers' compensation is a worker's legal right. If you are injured or become sick at work, you are entitled to workers' compensation. It cannot be negotiated and it cannot be signed away. Also, we want to note that immigration status is not a factor, and the board does offer free language assistance if you would like it. So, what is the role of the Workers' Compensation Board? The board administers and oversees the workers' compensation system. However, as previously mentioned, we do not typically pay the claims unless the employer has failed to provide proper workers' compensation insurance. We have approximately 1,000 employees across 24 offices and hearing points nationwide. Our role is to ensure the system operates correctly by receiving reports of all injuries, payments, medical reports, and any other documents relevant to the claim. We will also hold hearings in front of an administrative law judge when appropriate to adjudicate to move a claim forward. So hopefully that gives you a high-level understanding of the workers' compensation system, your rights, and your benefits if you become injured or ill on the job, and the role of us here at the board. Now, let's discuss what you need to know and what actions you should take if you contract COVID-19 at your workplace. The very first thing to do when you are sick or injured on the job is to seek treatment. In an emergency, you can see any healthcare provider. But otherwise, please go to a provider who is authorized to treat injured workers by the Workers' Compensation Board. You can find one using the provider search on our website at wcb.ny.gov. You can also visit your local New York State occupational health clinic for treatment from an authorized provider. You can search for your closest clinic on the Department of Health's website, and you can see that link right there on your slide. Tell the provider who treats you that you believe you contracted COVID-19 from an exposure at work. Share any details about your workplace to back that up. For example, how would you describe your workplace? Was there public contact? Were masks worn? Did your coworkers have COVID-19? As well as any other circumstances the provider should know about your potential exposure. If your healthcare provider agrees, they will send a medical report to the insurer and to the board. It is best that the medical report includes your positive COVID-19 test result, but a medical report showing a diagnosis via a PCR test or by virtue of an examination may also be used. You will need to notify your employer in writing that you believed you contracted COVID-19 at work. An email or a document is best. A text message can be accepted, but it's not recommended because it's not easy to find and duplicate it if necessary. Notify your employer as soon as you can, but no later than 30 days of becoming ill. Your employer is then required to notify its workers' compensation insurance carrier. Now, let's take a look at how to file a COVID-19 workers' compensation claim. First, you should file a claim for workers' compensation. Workers are not required to file a claim because the insurance payer must notify the board of the incident. However, filing your own claim is valuable protection and is extremely helpful, as I'll explain here in a few minutes. As Joe mentioned earlier, you have 2 years from the time you contracted COVID-19 to file your claim. So again, if you are approaching this deadline, please file the claim as soon as possible. The fastest way to file is using the employee claim form, which is Form C3, and that can be found online at the link on your screen. You can also file a paper form, which you can download from our website. Again, right there on your screen is where you can get that form. And just follow the instructions on the form and submit it to the board. If you have a PCR test result showing that you had COVID-19, file that report. That will be very important to your claim. If you had COVID-19 early in the pandemic and you got your results by phone, as many people may have, you should now get that result in writing, and please file that. So what do you need to share in your claim to show your COVID-19 illness is work-related? Most workers cannot point to the exact moment or method of exposure to COVID-19. However, you can demonstrate a high risk in your workplace if you work in an environment where exposure to COVID-19 is or was prevalent. For example, if you work in a hospital, if you're in a transportation job, if you're at a grocery store, or really anywhere else. On the claim form, include details about where you work, how often you work, and your job duties, especially those involving public contact. Section D of the claim form does have space for you to share any relevant details. And while not all claims will be accepted, there is no harm or risk in filing a claim, even if it ends up getting denied. Filing a claim is important for anyone who believes they contracted COVID-19 at their job, especially those who are missing work or experiencing ongoing symptoms. There may be benefits that can help you right away. If you're experiencing long-haul medical issues due to work-related COVID-19, you may be eligible for free lifetime medical care. If you miss more than 7 days of work due to work-related COVID-19, you may be eligible to receive lost wage benefits. This may be very helpful to long-haul sufferers who regularly miss time from work due to medical appointments or worsening symptoms. For anyone who contracted COVID-19 on the job, whether or not you had access to and used paid sick time, and whether or not you've since recovered, it is important to have an established claim, a record that your COVID-19 was work-related, should you suffer long-haul complications and need workers' compensation benefits down the line. If you already have an established claim for COVID-19, any lost wage benefits or ongoing medical care that is directly or consequently related to COVID-19 falls under that existing claim. So for example, someone with an established COVID-19 claim may also need ongoing treatment for problems from COVID-19 related to their kidneys or their lungs, or they may develop consequential conditions such as anxiety or depression. If you need help filing a claim, you can call our toll-free number. It's a customer support line at 877-632-4996. And again, free language assistance is also available should you need it or should you like it. If you face resistance or obstacles to getting information about the claims process, or if you're discouraged from filing a claim, please let us know. We will help you. You can email our Advocate for Injured Workers at advocateforinjuredworkers@wcb.ny.gov. So, what happens once you file? If the insurer accepts or agrees with the claim, it will be payable, and this is known as compensable. If the insurer disputes the claim, a judge at the board will decide whether the claim should be paid. Right now, everyone has to attend our hearings remotely because our offices are closed to the public. While the attorneys must attend by video, injured workers have the choice to either participate by telephone or by video through our virtual hearing center, which you can download on the App Store. It's called the Workers' Compensation Virtual Hearing App. And your hearing notice will contain all the details once you receive it. The judge may hear testimony to get the facts about where you work, whether you were exposed to COVID-19, the extent of exposure, and whether exposure to COVID-19 was prevalent in your work environment. Remember, you do not need to pinpoint a moment in time when you think you were exposed. We review all the facts in a claim. From there, it is possible to appeal a judge's decision, and we have an appeal process if that happens. We just want to note real quick, if you file a claim within 2 years of contracting COVID-19, but your claim has not been established, meaning neither the board or the payer has determined it was a work-related illness, for some reason, for example, there was no medical evidence submitted, or you fail to appear at a hearing, your claim may still be established based on the following conditions and respective timelines. If a hearing was held, you received notice of the hearing, and your claim was marked no further action rather than closed, your claim may still be established if a request to reopen it is made within 7 years of when you contracted COVID-19. If no hearing was held, Your claim may still be established if a request to reopen is made within 18 years of when you contracted COVID-19. Such requests to reopen claims may be made by using the Request for Assistance by the Injured Worker, which is Form RFA 1W, or its online version, which are both available on the Form section of the board's website at wcb.ny.gov. Now let's take a look at some additional resources that we have available for you. For more information related to COVID-19, including quick links for finding an authorized workers' compensation provider and filing a claim, please visit wcb.ny.gov/COVID-19. On that page, you'll also find numerous resources such as fact sheets, frequently asked questions, and more. You can also subscribe for email updates related to COVID-19 and workers' compensation by selecting the Subscribe for Updates button on the top of the page. For other helpful information for workers on workers' compensation and other topics, you can visit the Workers page of the board's website at wcb.ny.gov. Finally, as mentioned earlier, our Office of the Advocate for Injured Workers is ready to help injured workers who are having difficulties with their claims or trouble accessing their benefits. You can contact the Advocate's office by calling 877-632-4996, or you can email advocateforinjuredworkers@wcb.ny.gov. We do have a very active social media presence as well to help you stay informed on workers' compensation topics and from the latest news on the board. Make sure you're following us on our social media channels so you can learn more about future webinars like this one, as well as information and webinars on New York State's paid family leave. Our Twitter, Facebook, Instagram, and YouTube handles are here on the screen, and I strongly encourage you to check out our YouTube page for recorded webinars on this presentation. This will be updated and uploaded to our YouTube page. So I see a question already asking if the slides will be available. We will have a copy of this slide deck as well as a recorded version of this webinar on our YouTube page. And you will be notified via email when those are available. So again, make sure you are signed up for our email notifications. Just go to our website, scroll down to the bottom of the homepage and select Get WCB Notifications. You get to choose the topics you'd like to subscribe to. Thank you for attending this presentation on COVID-19 and workers' compensation. We hope you found this information helpful, and we will now take the rest of your time to answer any questions you may have. Again, please enter any questions you have in the chat box, which is located on the right side of your screen. I'm now going to turn it over to our subject matter experts to answer your questions. There may be some brief periods of silence as the questions come in and they review them, but we will start looking at your questions, and I'm going to hand it now over to Dr. Tachi, Joe, and Heather.
Our worker would like to know what to do if the worker does not currently have symptoms, but definitely contracted COVID from the worker's hospital-based job. Should I file anyway, is the question. And the diagnosis was January of 2022. So a little quick math, you're within your 2 years. So yes, we would suggest that you file a claim. And we're happy that you don't have symptoms, but the importance of filing the claim is so that it is on record and you can hopefully establish that claim just in case in the future you do have some symptoms or anyone has some symptoms in the future, because that is something that New York and the world is confronting right now. It's usually called long COVID, colloquially speaking, and workers' comp provides a lifetime benefit for medical care. So if you do need some medical care in the future for the COVID that was contracted maybe years in the past, you will have that available to you. This is one of the primary reasons we're doing this webinar, so that people have that recourse and have that potential treatment available to them in the future.
This is Dr. Tachi. There are a few related questions that I'll sort of try to summarize into one. Basically asking, how do you clinically prove if you have COVID, or if you have long COVID or post-COVID syndrome, et cetera. And unfortunately, Adam mentioned earlier that if you do have PCR test results, then those should be submitted with your claim, et cetera. Unfortunately, we can't give folks a specific answer because of all of the variables that are associated with contracting COVID and determining whether or not someone has COVID, whether or not it was related to their job, et cetera. So the single best recommendation that we have is that if you think, so first of all, if you have COVID, you should get treated, et cetera. And if you have post-COVID, then you should get treated for those symptoms. But the single best recommendation that we have is to raise the question with your doctor, raise the issue with your doctor, say that I think, you think that your COVID is related to work. And this is why, based on the type of job that you have and the type of exposures that you may have had and the timing of your illness with your work activities and whatnot. And then you and your doctor will compile all of that into your medical record. If you and your doctor think that the COVID is work-related, or that your post-COVID syndrome or conditions are work-related, then you could submit them to the workers' comp carrier as such, and they'll either accept that or not. And if not, then all of that information will be compiled and go to one of our administrative law judges, where they can weigh up the pros and cons of both arguments. So there's not a simple answer, but just take all of the reasons and evidence that you believe you have either COVID or a post-COVID condition, and that those are related to work, and discuss those with your physician.
Hi, this is Heather McMaster. There's a question about how this affects remote workers who are working remotely for a company in another state. When you're looking at a workers' compensation claim here in New York, it is where the worker is located. So if you work remotely for an employer and you work in New York State, then you will be eligible for workers' compensation benefits in New York State. Depending on the factors surrounding your remote work, you will still need to demonstrate that it's causally related to your work. If you're sitting in a room in your house, that may not be sufficient to demonstrate that your work was the reason that you caught COVID, as we talked about in the webinar, or Adam talked about in the webinar. We look to the prevalence in your workplace in determining whether there's causal relationship to establish a work-related COVID claim.
And to continue that train of thought from Heather, there is a principle here that is applicable or is going to be applied whether you worked at home or whether you worked in an office setting, because someone's posing that question, or whether you worked in a hospital or wherever you worked. Here is the principle. What is the likelihood you got COVID on the job? So yes, there might be different likelihoods in one setting or another, but when you're filing the workers' comp claim for COVID, you are demonstrating the likelihood that you got it at work. You're talking about the prevalence in your workplace, be it a hospital or an office or a supermarket or any place else. We also have a few questions on FMLA, and we can address that for you briefly to this extent. FMLA is the Federal Medical Leave Act. That is a federal law, so it's not a New York State workers' comp law. It's the federal government, and those are the 12 weeks of time off from work due to an incident that are protected under the Federal Medical Leave Act, FMLA. So the only place where the FMLA and workers' comp meet or intersect is, yes, it is possible that you could be using your 12 weeks of FMLA time while you're on your workers' comp claim. Yes, it is possible. We don't have any other intersection or crossover with FMLA. If you have those questions on the FMLA, well, I do know that the Federal Department of Labor has offices in New York State, and I do know these people personally, and they are pretty committed people, so you can pose your FMLA questions directly to the Federal Department of Labor. It's beyond our jurisdiction and our ability to really give you reliable information. So I'm going to have to refer you there. We have a question about insurance payers not accepting COVID claims or maybe disputing them. That's why we have hearings here at the board. It is possible for the insurer, as we mentioned, to dispute a COVID claim. They can dispute a claim for any injury or illness in the workers' comp system. And the remedy or the recourse that the worker has is a hearing here at the New York State Workers' Comp Board. We will have those in these claims like we would in any other claim. And just another note on that, if you do have a hearing, it's going to be a virtual hearing today. Our offices are closed to the public. They've been since March of 2020. However, we have not missed any hearings either because we do have the virtual hearing capability. As in, if you have a hearing, you're going to get a notice from the board several weeks ahead of time. It's going to come in the U.S. mail, and it will contain the directions for joining your hearing. So if you get that notice, please pay particular attention to how to participate in the hearing. And if you're an injured worker, we are urging you to join that hearing. Even if you have an attorney, you should still be there.
Now, this is Dr. Tachi. There's a question that I'll summarize. What happens if you contracted COVID from a previous employer? It references September of 22 for the positive testing, and then presumably out of work treatment, et cetera, but you now work for a different employer. Should you still file a claim? And the answer is yes, as Joe indicated earlier and Adam indicated earlier. It doesn't say whether or not the person is experiencing any post-COVID conditions, but if you are, or if you should end up experiencing those conditions, you will want to avail yourself of whatever the appropriate medical care is moving forward. And the only way to assure yourself of that would be to file the claim, and that claim would of course be linked to, if it were work-related, to the employer that you were employed by at the time of the COVID, not your new employer, right?
This response is specific to one of our questions, the question that came in at 1234. It's the question, we got two of them at 1234. I'm sorry. One of them is very simple, and I will do that one second. But the first one, which is the lengthy scenario someone posed about having a hearing in October of 2022, please write to my office with that question, with your WCB case number. The address for my office is right on screen. It's the very last bullet. You have a very detailed question that involves a very detailed scenario that we're going to have to look at with you offline, right? And obviously we have our email address there because we will do this. So if you also haven't posed a question, but you have a very detailed question about your particular scenario, please take advantage of the contact information. You can telephone or you can write, and we will help you directly. The other question that came in after The other question that came in at 12:34 has to do with the 30-day time to notify your employer. Go ahead and notify your employer after the 30 days and go ahead and file the claim. Don't exclude yourself. Go ahead and do that. We will see what happens with the claim, and if some reason happens for hearing, we'll hold the hearing, but go ahead and file the claim. Don't exclude yourself because of your reading of the rules. Again, so long as you filed a truthful claim, even if it's not established, there's no penalty.
There's a question, if the COVID was contracted in an office setting and not in a hospital setting, would an employee still be eligible to file? And that would go back to our earlier discussion. Basically, every individual case is different. Every set of circumstances and exposures are different. If you, as the individual with the case of COVID or the prior case of COVID, believe that the office setting, that there's a reason to believe that in that office setting constituted your exposure to COVID, then discuss that with your doctor, and he or she will work through that exposure versus other possible exposures. And if you both think that it's that the case is work related, then you would file. And so there's no magic setting that you have to be in a hospital or you have to be in that type of a healthcare setting, et cetera. If you, no matter what your work setting is, if you believe that that is what caused your COVID and what caused your exposure, then you should discuss it with your physician and file the claim.
We also have a general question that I think is worth explaining as long as we have everyone here. The question is, how long can I stay out on workers' comp leave? And the way workers' compensation operates is a healthcare provider, your treating provider, you're the worker, your treating provider is going to give an opinion on how disabled you are. And it's going to be a number from 0% to 100%. 0% disabled means you're healthy. Wonderful. 100% disabled means that provider is saying, I don't think you can work. So the idea of how long can I stay out? Well, it's going to be based on how disabled you are. And sometimes it comes to the board for a decision, and one of our judges will make the decision of how disabled you are, if necessary, based on the medical reports that are in your file, based on the medical reports you have. So there's really no clear-cut answer of how long can I stay out. If you're 0% disabled, you're going to go back to work. You're 100% disabled, you have a provider saying that you reasonably cannot be expected to work.
There's a question about whether or not the employers are required to post the 2-year window. Every employer is required to post a poster, which is prescribed by the board, in a public place. Often it's a break room, and it advises of your right to workers' compensation benefits and who the workers' compensation carrier is. I don't believe that the 2-year statute of limitations, which is what the 2-year window is what we call it, is included on that information.
All right, so no other questions have come in, so we're going to go ahead and wrap up. Thank you, everyone, for joining us today. Thank you to Dr. Tachi, Heather, and Joe for joining us. We always appreciate everyone's participation. And just a reminder, for more information related to COVID-19, including quick links for finding an authorized workers' compensation provider and for filing a claim, you can visit the website on your screen there at wcb.ny.gov/COVID-19. And again, as I mentioned, make sure you sign up for email updates so you are aware of when this recorded version is available, as well as more information that may be coming up related to COVID-19. If you go to the wcb.ny.gov, scroll to the bottom of the homepage, select Get WCB Notifications, and you can choose the topics you'd like to subscribe to. For other helpful information for workers, you can visit the workers page of the board's website at wcb.ny.gov. And again, don't forget to also follow us on Facebook, Twitter, and Instagram, where we also update regularly with news and updates. Thank you again for joining us today, and please enjoy the rest of your afternoon.